some changes have been made to the massive tax, including ones that would loosen regulations on gun suppressors.
My Second Amendment deals with to eliminate the $200 tax on silencers.
That would prohibit the sale, transfer, production, and possession of gun silencers.
It's outrageous that they would spend $1.4 billion to make silencers cheaper.
It has been almost a century since the federal government put strict limits on gun suppressors.
It has everything to do with making money for a certain segment of the gun industry.
The entire legal foundation of one of America's oldest gun laws might be crumbling, and the government just showed its hand on how it plans to stop that from happening. A massive legal battle is unfolding right now over the National Firearms Act, and what just happened in this case changes the entire trajectory of the fight. The plaintiffs challenging the NFA didn't just argue that the law is being applied unfairly. They went much further. They brought in a brand new Supreme Court ruling and used it to argue that the NFA may no longer be constitutional at all. And the government's official response to that argument reveals exactly how desperate and how strategic their defense has become. This is a developing legal story with enormous implications for every firearms owner in the country, and the details matter here. So let's walk through everything that just happened. To understand why this case is so significant, you have to understand the history behind the NFA and why it existed in the first place. The National Firearms Act has been on the books since 1934. It covers items like suppressors, short-barreled rifles, short-barreled shotguns, and a category known as any other weapons. For decades, if you wanted to legally own any of these items, you had to go through a lengthy registration process, submit to a background check, wait months for approval, and pay a $200 tax stamp. That tax stamp is the key to this entire story. When the NFA was first challenged in court many years ago, it survived because the courts treated it as a tax. The reasoning was straightforward. Congress has broad authority to levy taxes. The NFA imposes a tax on certain firearms transactions. Therefore, the NFA is a valid exercise of Congress's taxing power. That was the constitutional justification. That was the pillar holding the entire structure up. And for nearly a century, that pillar stood unchallenged in any meaningful way. Then Congress did something that nobody expected to have such profound legal consequences. Through recent legislation, Congress reduced the NFA tax to $0 for several categories of items, including suppressors, short-barreled rifles, short-barreled shotguns, and any other weapons. On the surface, this seemed like a win for gun owners. No more $200 fee to exercise your rights. But beneath the surface, this change created a legal earthquake. Because if the NFA was always justified as a tax and now the tax is literally zero, what exactly is holding the law up anymore? That is the question at the heart of this case, and both sides have very different answers. The plaintiffs in this challenge have been building their case methodically. Their core argument is elegant in its simplicity. The NFA was upheld as a tax. The tax is now gone. Therefore, the constitutional justification for the NFA is gone. What remains, they argue, is not a tax at all. It is a pure regulatory scheme. It is a system of registration requirements, waiting periods, background checks, discretionary approvals, and severe criminal penalties for non-compliance. And the plaintiffs argue that this system cannot stand on its own without the taxing power to support it. They have been backing this argument up with real-world evidence showing how the ATF administers the NFA in practice. And the picture they paint is not flattering to the government. They have presented evidence suggesting that the ATF exercises significant discretion in how it processes applications, that the system does not function like a neutral shall-issue framework, and that the practical effect of the NFA is not taxation but restriction and control. In other words, the plaintiffs are saying that even before the tax went to zero, the NFA was already behaving more like a regulatory ban than a tax collection system. Now that the tax is literally nothing, the mask has come off entirely. But here is where the case took a dramatic turn. The plaintiffs didn't stop at their original arguments. They filed what is called a notice of supplemental authority, which is a way for parties in a lawsuit to bring new legal developments to the court's attention. And the new development they pointed to was a Supreme Court decision that came down earlier this year in a case called Learning Resources versus Trump. The plaintiffs argue that this ruling reinforces a strict separation between Congress's taxing power and its regulatory powers.
That would prohibit the sale, transfer, production, and possession of gun silencers.
It's outrageous that they would spend $1.4 billion to to make silencers cheaper.
Some changes have been made to the massive tax, including ones that would loosen regulations on gun suppressors.
It has everything to do with making money for a certain segment of the gun industry.
The logic goes like this. If the Supreme Court is drawing clear lines between what counts as a tax and what counts as regulation, then a law that was justified purely as a tax cannot simply transform into a regulatory scheme when the tax disappears. The NFA was sold to the courts as a tax. The tax is gone. And under this new Supreme Court reasoning, the plaintiffs argue you cannot just swap in a different constitutional justification after the fact. The law has to stand or fall based on the power that was used to enact it. This was a bold strategic move by the plaintiffs because it elevated the argument from a narrow challenge about how the NFA is administered to a fundamental constitutional question about whether the law can even exist anymore. And now the government has officially responded, and their response is extremely revealing. The Department of Justice filed a detailed rebuttal to the plaintiff's supplemental authority, and they are pushing back hard on every front. Their response tells us not just what they think about this particular argument, but how they plan to defend the NFA for the foreseeable future. And their strategy involves several distinct layers. The first layer of the government's defense is relevance. The DOJ argues that the Supreme Court case the plaintiffs cited has absolutely nothing to do with the NFA challenge. They point out that Learning Resources versus Trump dealt with a completely different legal question, specifically whether Congress had properly delegated tariff authority under a particular statute. The analysis in that case, according to the DOJ, was about statutory interpretation and delegation of power, not about Congress's constitutional authority to regulate firearms. So the government's first move is to tell the court that the plaintiffs are importing reasoning from an entirely unrelated context and that the court should disregard the citation altogether. The second layer goes deeper and attacks the plaintiff's underlying premise. The plaintiffs argued that there is a strict constitutional wall between taxing and regulating, and that the Supreme Court's recent decision reinforces that wall. The DOJ flatly rejects this characterization. They argue that the Supreme Court did not establish any rigid boundary between Congress's different enumerated powers. They argue that the Constitution does not require Congress to choose one single power when it passes a law, and that Congress has always been free to rely on multiple constitutional authorities simultaneously. And this leads directly to the third and most consequential layer of the government's defense. This is the argument that changes the entire nature of the case going forward. The DOJ is now explicitly arguing that the NFA was never based solely on the taxing power. They claim that when Congress passed the NFA in 1934, it was exercising both its taxing power and its power under the Commerce Clause. The Commerce Clause gives Congress broad authority to regulate interstate commerce, and the government is arguing that firearms regulation falls squarely within that authority. So even if the tax component has been reduced to zero, even if the taxing power justification has weakened or disappeared, the DOJ says the NFA can still survive as a valid exercise of Commerce Clause authority. The law always had a dual purpose, they argue. It was always about both taxation and regulation, and because the regulatory purpose remains intact, the law stands regardless of what happened to the tax. The DOJ also makes a procedural argument about legal frameworks. They argue that the plaintiffs are applying the wrong analytical tool to this case. The Supreme Court decision that the plaintiffs cited involved what is known as the major questions doctrine, which is a judicial principle used to interpret ambiguous statutes. But in this case, the court is not interpreting an ambiguous statute. The court is dealing with a direct constitutional challenge to an act of Congress. According to the DOJ, those are fundamentally different types of legal analysis, and the framework from the Supreme Court case simply does not apply here. So now let's step back and look at the full picture of what is happening in this case, because the battle lines are now extremely clear. On one side, the plaintiffs are making a focused, targeted argument. The NFA was justified as a tax. The tax is now zero. The law has lost its constitutional foundation. A new Supreme Court ruling supports the principle that you cannot simply swap a taxing power justification for a regulatory power justification after the fact. The NFA should fall. On the other side, the government is making a broad, expansive argument. The NFA was never just a tax. It was always supported by multiple constitutional powers. Congress can rely on both the taxing power and the Commerce Clause at the same time. The reduction of the tax to zero does not eliminate the Commerce Clause basis for the law. The Supreme Court case the plaintiffs cited is irrelevant, and the analytical framework the plaintiffs are using is wrong for this type of challenge. This creates a fundamental clash that the court must now resolve, and the outcome depends on which vision of the NFA the court adopts. If the court agrees with the plaintiffs that the NFA was historically justified as a tax, and that the tax is the only thing that made it constitutional, then the $0 tax change could be fatal to the entire law. But if the court agrees with the DOJ that the NFA has always rested on multiple constitutional foundations, then the law could survive even without a functioning tax. And this is not just an academic question. The stakes here are enormous. If the NFA falls or is significantly weakened, it would transform the legal landscape for suppressors, short-barreled rifles, short-barreled shotguns, and other currently restricted items across the entire country. If the NFA survives by pivoting to a Commerce Clause justification, it would set a precedent that could make the law even harder to challenge in the future, because the Commerce Clause is one of the broadest powers Congress possesses. What makes this moment so critical is that the government's response reveals their long-term strategy. They are not conceding anything about the tax issue. They are not retreating on any front. Instead, they are expanding their defense. They are building a fortress around the NFA by arguing that it has multiple constitutional supports, so that even if one support is knocked out, the others keep the structure standing. This is a deliberate and calculated approach, and it tells us that the government views this challenge as a genuine threat. You do not deploy this kind of multi-layered defense unless you believe the other side has landed some real blows. The next major development will come when the court issues its ruling on the competing summary judgment motions. Both sides believe they should win without even going to trial, and the court will have to decide whether the NFA's constitutional foundation is intact or whether it has been fatally undermined by the elimination of the tax. Every piece of this puzzle matters. The historical record of why the NFA was passed, the legal reasoning courts have used to uphold it for decades, the practical reality of how the system operates today, the implications of the $0 tax, and the relevance of new Supreme Court precedent. All of these threads are now woven into a single case that could reshape firearms law in America. This story is far from over. The court has received arguments from both sides, and a decision could come at any time. When it does, the ripple effects will be felt across every state, every gun shop, and every firearms owner who has ever navigated the NFA system. Whether the NFA stands, falls, or is forced to transform into something entirely different, the answer is coming. And based on what both sides have now put on the table, the court has everything it needs to make that call. That's it for today, folks. See you in the next video.